And meanwhile, we are waiting for our guest. So, can anybody please tell me? Let's have some discussion. Can anybody please tell me what we are going to discuss? Do we know the purpose of this meeting? You may open your mic if anybody is willing to speak on the topic. We have number of participants here. Uh, Meanwhile, the guests join us. Let's talk about the topic. Anybody is willing?
Yes, this is Kaim Khan Jatoi, final year student from Chaizul Paralipito University of Law. Topic of our session is the international law to protect environment. Uh, as far, in my view, it is simply that we are discussing the role of international law to protect the environment. It means that the implication that can be made to the international law and the things can be added to the international law to protect and make it more executable so that the environment of our globe can be saved. This is what I understood from briefly from this topic.
Very good. Yeah, exactly. Okay. So, Qasim, you have explained very well. So, next, can anybody
Sorry,
share
it's Kaim.
that?
It's Kaim.
Kaim, sorry, Kaim. Thank you very much for correcting. Okay. Can anybody please share what article is added in our new 26th amendment, which is very notorious? Okay. What article is added to prevent this environmental hazards? Okay, Kaim, you may answer.
Yeah, it is Article 9A regarding the protection of environment.
Okay, very good. I wasn't expecting this, but it's very good. You are well aware of these steps taken for environmental protection. Actually, 9A explains that sustainable steps would be taken, and actually, a good environment is a fundamental right. So, if anybody else wants to speak on this issue, meanwhile, the guest joins us. Hurry up, open your mic. Hello. Meanwhile, I'm adding new participants in the session. Okay, we have Miss Binish with us. Assalamu alaikum, ma'am. How are you? Ma'am, can you hear me?
Am I audible to you, Rehan?
Yeah, you are audible. So we have
I
Miss
can't
Binish with
listen to
us.
you properly, actually. I don't know, like, why is it so bad? I think so.
Uh,
The problem is a setting problem.
okay, let me ask participants.
Just bear with me for a
Am I
minute. Let me
audible
just
to
connect
all?
everything, yeah? Hold on.
Sure. Am I audible? Sure. I can see these like reactions. Do we have Alina with us? Alina, are you there?
Yes, sir. Yes, sir. Assalamu alaikum. Am I audible?
Walaikum salam. I was waiting for you. Yeah, you are audible and
Oh,
you may continue.
I'm really sorry. Assalamu alaikum. And today I'm going to start the session with a really beautiful quote that goes like this: the environment is where we all meet, where we all have a mutual interest. It is that one thing that all of us share. Good evening, everyone, and thank you all for joining this session. I am Alina Abrar, currently pursuing my LLB at Punjab University, Jehlam. I'm in my fourth semester. And it is an absolute privilege having such an accomplished legal expert with us today. I'm sure we are all eager to learn from her vast experience. We have today with us Miss Beenish Shehbaz Ivan, who is a legal professional holding 3 gold medals, one in her Masters in International Relations and two in her LLB. She is currently practicing as an attorney in London, specializing in immigration and international law cases, and she has completed her LLM from the University of Essex. She is also a patron in chief of Wakalat Online since last year. Today, we are here to discuss an increasingly important topic, the greening of international law to protect the environment. This discussion will shed light on how international legal frameworks are evolving to address the environmental challenges and shape a sustainable future. Now, just a quick reminder, let's keep the session smooth and productive. Please remain muted unless you have a question and feel free to ask once Miss Beanish has finished speaking. If at any point the speaker is not audible, you may inform us through the chat box. One more thing. During the session, you have to fill the attendance form. It would be given to you in the chat box. Without any further delay, I now invite Miss Beanish to take the floor. Over to you, ma'am.
Ma'am, actually, you are muted. We can't hear you. May
Am
you
I
please
audible
turn your
now?
mic on?
Am I audible now?
Yeah,
Hello.
yeah, you are audible.
Perfect. I say like hello. I didn't know like if I have to say like good afternoon or good morning to all of you, because in United Kingdom it's good morning, but I think in your area it's good afternoon already. So assalamu alaikum everyone, and thank you so much first of all for such a nice introduction, Alina. Do we need to wait for some more participants, or like do we need to start? What we have to do?
I think we should start as we have very few minutes left to discuss this vast topic. We'll have another link if you are visible with the time.
Maybe I would need another link, but I'm not sure about it so far. But um, first of all, let's wait for 2 more minutes and then we'll be start working on it. Yeah.
Sure, sure.
And yeah, one more thing, if I can request all of you to just turn on your cameras so that I can have a discussion face to face with you guys, because it's really very important to have a discussion face to face. So if I can request all of you to turn on the cameras, if there is no privacy issues and everything, please.
I think they're not comfortable. I
But they have to, because I believe in it. I mean, I believe in it's not a lecture, it's just a conversation between us uh, on a topic. That's my thinking, and I don't believe in it. Like, if one person just keeps on talking all the time, and the other person is just listening and they don't have any contribution or active participation in anything. So that's why I'm asking everybody to just turn on the cameras. I mean, it's really very important. I can have a discussion. Otherwise, I'd be thinking like I'm talking to a wall. Okay, up to yeah. So perfect, right. I would ask you guys to just turn off the mic so that we can have a conversation. And even in my lecture, if you guys think like we need to ask some questions, just raise your hands and then we'll be discussing the points even during the lecture, because it's just the seminar. A seminar. So in seminar, everybody is basically is allowed to have a conversation. Okay, without wasting any time, our topic today is the greening of international law to protect the environment. Sometimes it seems a little bit weird, like when we discuss about the international law in particular, and then the environmental stuff. and all that. Um, First of all, before I start, let me just tell you one more thing, which is very important. I think it's extremely pertinent here to discuss is that international law is very broad. It's a very, very, very wide topic. It's a amalgamations of so many laws all over the world. Just bear in mind one thing. And environmental law is just a little part of the international law. It's just a little part. But now, with the passage of time for the last 4 to 5 years, this area of interest in international law has basically taken so much interest and the attention of international jurists all over the international arena. It has to be bear in mind before we start the lecture. So if you ask me the question about like where we have concluded as far as international environmental law is concerned, I would say like it's still continuing, it's still in progress, and it will be in progress even if we die one day. And we have to, there's no doubt in it. But the thing is that it's such a vast topic and it has taken a lot of attention of international jurists and international scholars all over the world. So, and in this lecture, you know, when we discuss about so many things, I'm not going to go into the cramming of something. I mean, if I just keep on telling you about the international treaties, names of international treaties, you can search online, you can search on Google. But in my seminar, in my lecture, what I'm going to give that to you right now, it's not about the cramming of so many things, and in 1990 this happened, in 1992 this happened. No, my task is not this. I'm just going to be discussing about the principles of basically international law that has to be included and that actually works to protect the environmental law. That's basically the part of the of our today's lecture, that the greening of international law to protect the environment. So let's start it now. As you know, like international law, in a traditional view, uh, basically it it consists of the ideas, and there are so many sources of international law. For example, under Article 38 of International Court of Justice, as you already know, that it's written that international law basically is taken, and the concepts of international laws are basically taken from international conventions, international customs, generalized principles of law, which is recognized by the civilized nations, teachings of highly qualified people, and of the jurists as well. So this is all about the international law. That's the traditional view of international, because it's not coded anywhere. If you talk about international laws in coded form, like where it is written, from where we have to follow the international laws and all that stuff, it's not written anywhere. But it's derived from it's a traditional view of international law since it started after the Cold War, and even during the Second World War and all that stuff, international law basically touched the skies, and it just started developing, and many people from all over the world just started learning international laws and all that stuff. And then for the last 4 or 5 years, environmental law has taken extremely a boom of it, but still it's continuing process. But it has developed so much, and I'm going to be discussing about that in my lecture right now today. So as I was mentioning earlier, that the traditional view of international law is that it is derived from different conventions, from different customs, from different treaties, from different declarations, from the you can say the judgments of international tribunals and all that stuff. That's how we derive the international law. But it's not coded anywhere. So the question comes to our mind when we talk about this, that if it's not basically you can say coded, so how are we just going to know about the environmental stuff then? How are we going to get to know like what principle applies to the environmental laws and everything? That's actually a very it has a basically different discrepancies here. So many questions come to our mind and all that stuff. Okay, Rayan, let me just ask you one more question. Is this recorded? I think it should be recorded, this lecture, so that people can get to know about that later on whenever they require. Is it so?
Ma'am, I think Mr. Saad is here. I don't confirm it,
Yeah,
but I
yeah,
can
please.
turn on recording from my end.
Yeah, please do it, because the thing is that if I'm talking, so many people, if they have some different questions, or maybe they can refer to whatever I'm saying right now in their future, and they'll be just listening to the lecture again and again, again and again whenever they require. I think it's really very
Sure, ma'am.
important.
I'm putting it on recording.
Yeah, you should have done it earlier, anyways, but it's all right.
Yeah, I think Mr. Saad is doing so, but I can't confirm it now. But it's being recorded now.
It started. Because I'm going to be discussing about different case laws, and it's really very important that if people have any questions further, so they'll be just pinpointing or underscoring that case law later on.
Sure, ma'am. We are being recorded.
Ma'am, we are recording on three different laptops now. Don't worry.
Perfect,
We will
perfect.
share the recording in the group as well.
It's good.
Thank you.
Okay, so as I was just mentioning earlier, the traditional view of international laws, that it's derived from different, different elements, different customs, different conventions, different the teachings of highly qualified people, and the generalized principles of laws, which is basically accepted by the civilized nations as well. And it's not coded at all. International law is not coded at all. So the question comes to our mind is like, if it's not coded, so the environmental, as far as the environmental stuff is concerned, so how are we going to get to know like what principle applies to the environmental law if we have to relate it to the international stuff? There are so many ways of it. There are some principles of international law which I'm going to be discussing. There are, I think, 7 or 8 principles, and I'm going to be discussing all these principles right now with all of you guys. Have a paper, have a pencil with you so that you can keep on writing, because I didn't prepare the presentation. I don't like it. So the first principle is the sovereignty and responsibility of international law. Don't worry about it, like I'm not talking about environment so much so forth right now, because I'm going to be linking the environmental laws to the principles of international law, and then how that's how you will get to know, like, to protect the environment. There are so many environmental problems. For example, there's a problem of ozone layer depletion, there's a problem of maritime jurisdiction, there is a problem of biodiversity, there is a problem of land resources, there is a problem of uh, green gas emissions, there is a problem of HSC gases. HSC gases are those gases which are basically put in the refrigerators or in the air conditioners. I will let you know like how these gases are basically causing the problems as far as the international environment is concerned. So it's not protecting the environment at all, at all. After that, there are so many problems. There is basically a problem of the wildlife as well. There is a problem of different um, you can say the population of the animal flow. There is a there is a problem of the different species all over the world. There is a problem of the light, there is a problem of the air pollution, there is a problem of the space pollution, there is a problem of transboundary air pollution. I'll be discussing about transboundary air pollution later on, but as far as environment is concerned, so there are so many problems there. So, how the international law is going to be protecting these problems and the environment? That's basically our today's topics discussion. And first of all, is the first principle of international law that is dealing to protect the environment is sovereignty and responsibility. Now, as you know, like sovereignty, there are two basically contradicting principles of sovereignty. The first principle is that the sovereign states have sovereign rights over their natural resources. Obviously, it's a sovereign state. So as you are all, I mean, are a student of LLB, maybe there are some who have already done LLB honors, there are some who are doing LLM, or maybe there are some who are in different areas of their qualifications academically. But the thing is, like, as you know about the sovereign state, so whenever we talk about sovereignty, it means like we have the permanent sovereignty. We have the right over our natural resources. We have the right on the territorial sovereignty. We have the right on our land. We have the right on we have a right on the air. We have a right on the space. We have a right on everything which comes under our state. That's called sovereignty. Keep in mind one thing, that this is the traditional view of the sovereignty. It is also called territorial sovereignty, and United Nations General Assembly basically further affirmed this in 1961, stating that people have the rights, sovereign rights over the people of the land, over the natural resources of the land, over everything. And that's called the permanent sovereignty. We get to know about it. But always keep in mind one thing, like whenever we talk about this sovereignty, there is an other contradicting point. There is a contradiction of it. International law is basically working on it. There are certain jurists who are working on this international kind of law sovereignty stuff, but still it's under process. But many have actually concluded to the idea that even though sovereign states basically have the rights over the natural resources, over the land, over the territories, over everything whatsoever included in their state, at the same time, states should not cause damage to the other state as well. That's also the contradicting point of the sovereign state. So, as far as the 1961 United Nations General Assembly ideas are concerned, it was further informed that it's a permanent sovereignty. Keep in mind one thing, that as far as I'm going to be discussing about the different case law later on, just let me remind it. The concept of sovereignty is not absolute. It's not absolute at all. It is subject to the duty. And there is a particular general maxim of international law which says that the possession of rights imposes obligations as well, performance of obligations as well. We, being a lawyer, know very well that whenever there are rights, there are duties as well. So when the states say, like, we have the sovereign power, we have the sovereignty over each and everything, over natural resources, at the same time, there is a duty imposed upon the states to protect and not to cause damage to the other people's state, to the other state's environment, to the other state's natural resources. So there is a particular um, right and duty responsibility, though it's a little bit contradicting to the sovereignty concept of the state. And it is basically confirmed by, as I mentioned earlier in the start of my lecture, the international law is derived from 4 or 5 main elements, which is described in Article 38, subsection 1 of International Court of Justice. We are talking about conventions, we are talking about customs, as it's not written everywhere. This is no coded international law. We are always deriving international principles from something. So I'm going to be discussing about a case law right now, which actually confirms this idea that I am talking about the sovereign state, that sovereign state basically have the rights over their natural resources, but at the same time that the duty is imposed upon it. There is a case law. It's Texaco Overseas Petroleum Corporation and California Asiatic Oil versus Libya. I'll discuss about that. Maybe I will mention about that case law later on so that you can guys have a look after my lecture. Just remind me, Rianya. This case is of 1982. So it's actually mentioned about where there are duties, where there are rights, there are duties as well. So there is another important arbitration that has ever existed on this planet, as well as the environmental law is concerned. That's called trail smelter. It's TRAIL, trail smelter. It's SMELTER, arbitration. This arbitration, trail arbitration, has um, a very good scope as far as the environmental law at the international arena is concerned. And this, under this arbitration, it was stated that no state has the right to use or permit to use their land from any other state that can cause injury to other people's state and other people's responsibilities and all that stuff. Yeah. whoever has raised the hands will be discussing about the questions later on, right? Let me just complete the principles, then we'll come to it, and further we'll be discussing about the international treaties later on. So trace method actually says that no state has a right to use or permit to use their land so that it can cause injury to the other people. After the trail semester arbitration, United Nations General Assembly again thought about it and actually stated that the fundamental principle of international law imposes obligations upon all states concerning actions which might have harmful biological consequences upon people of other states with the increase in radioactive fallout. This all happened in 1960. Okay, whenever we discuss about international law, I am talking about it. I'm talking about the dates as well. You have to keep in mind about the dates. If I'm talking about 1960, you should have known like what was happening in the international arena at that time. If I'm talking about 1990s, you should know like Cold War actually finished that time. If I'm talking about 1980s, you should have known that there was a conflict between USSR and America at that time. So what is basically the concept of um, international relations and international laws, international arenas, all are affecting the environment. All are affecting the environment. If I'm just discussing about something, I mean, as far as the dates are concerned, so you have to keep in mind the dates. You have to go back to the history. Just relate my dates to what was happening in the international arena at that time. You will have a better idea. United Nations General Assembly in 1962 again confirmed, like, okay, if there are sovereign states, if there are the problem, obviously there is a right and there is a duty as well. That's everything is, I mean, everything is there. But at the same time, the radioactive fallouts are there because at that was the time when industrialized countries were civilizing more and more, more and more in the world. That was the era of industrialization in the world. That's why radioactive fallout came, and people actually just started discussing about it. International arena, international stuff discussed about it. Right. After that, for example, if there is a state who had like shared resources, for example, Afghanistan and Pakistan. Afghanistan don't have a, I mean, they don't have an access to water. So what they do, they basically access water from Pakistan. So they have the shared resources. So whenever there are the shared resources, so who is going to be applicable? Whose rights and responsibilities are there? This question comes to our mind. So the word that we use is that it should be equitable and harmonious utilization. For example, they after that they make basic consultation, they make different assessments of it. They have different meetings. Countries basically have different meetings, and they get to know like how we're going to make the equitable and harmonious utilization of all that things. If that's about, first of all, we have discussed about one state, then we have discussed about like if we have the shared natural resources. Okay, then there is another point. When you have the resources beyond the area of your national jurisdiction, that is called high seas. High seas are one of those areas in which no state has any applicability on it. Every state have access to it when you go to the high seas, because when you talk about marine jurisdiction, keep in mind one thing, that as far as waters are concerned, there is territorial zone, there are exclusive economic zone, there are different blah 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 blah. There are so many zones of the water. So after that, what happens? That there is a high seas as well, and in those high seas, every state has right to access the natural resources there. And how do we have to access those natural resources from the area beyond their national jurisdiction is with the concept of the common heritage of mankind. Write it down. Common heritage of mankind. If you write the common heritage of mankind, maybe I won't be able to discuss about that in detail in my discussion today, but it will definitely be of like much beneficial for you if you have a discussion later on of it. Okay, so this was the concept of the principle of sovereignty. There is another concept which is called principle of good neighborliness, neighbors. Principle of good neighborliness. This is closely linked to the duty to cooperate in investigation, in identifying, in avoiding any kind of the environmental damage. Being a neighbor, it's my duty not to cause damage to my neighbor country. That's the principle of good neighborliness. And how does it work? There are two further principles in the principle of neighborliness. And the first principle is the exchange of general information, and the second is consultation. As far as the exchange of general information is concerned, so basically, usually it is done at the domestic level. Every country has their, all over the world, every country has their basically general information criteria that they have to inform to the other countries that threat is coming. For example, you would have heard in the newspapers, or maybe in BBC or CNN, or maybe in Pakistani or any other news channels, that we have got an alert of flood. Why is it so? This is the principle of international law that is basically applied to let all over the world, to let the world know, and to let the neighbor countries that flood is coming. If there is an oil spit, you get to know about it. If there is a flood coming, you get to know about it. If the earthquake has happened in Afghanistan, Pakistan is get to know about it. Okay, in Islamabad area, that's gonna happen. That's gonna happen. This is the principle of general information. The second is the faith consultation, good faith consultation principle. This also comes under the principle of the good neighbor. What is this? For example, in the case of any emergency, the states basically consult with each other. Okay, we have put an industry in our area, and obviously the waste of that industry is going to go into the water. What's going to happen now? They consult with each other. They let the states know, like, this is something which is going to happen next. So that is basically the principle of good neighborliness. First, we have discussed about the principle of sovereignty. Second is the principle of good neighborliness. Second is the principle, it is called, yeah, preventive action. Principle of preventive action. Why we call it, I mean, every our internet issues by occur. Is there any internet issue from my side? Or am I
No, ma'am, it's going good.
okay?
Maybe,
Perfect. So maybe that person's internet connection
yeah.
is not appropriate, right? So that's why I asked you guys to have a recording of it, so if any people is just not able to listen right now, so they can have a discussion later on of it, or maybe they can contact us. Okay, so the third principle is the principle of preventive action. This is basically is that the state has to protect the other state from any damage, and there are different techniques of it. This is called the prevention, and the prevention says that you have to prevent yourself, and this means that you don't have to cause damage within your own jurisdiction. This is called, okay, right, so it's just like, you know, so this preventive action is that the states basically have to be 100% sure of it that they don't have to cause damage within their own jurisdiction first, because once they are going to be making a cause or environmental damage to their own jurisdiction, that's definitely going to affect the other jurisdictions as well, because environment is not something, it's not your home environment, it's your country environment, and in the country's environment your ozone layer involves, your air involves, your space involves, your water involves, your everything involves in it. So basically, so the discharge of the toxic substances, even in the water, or even in the land resources, or even in the agriculture places, even when the states are quite adjacent to each other, so then definitely it's a problem. So this principle basically suggests the states to not having or not causing any damage to the environmental problem, within the environmental damage to their own jurisdiction. And there are certain ways of it. The first basically states, what do? They establish the assessment techniques. They maybe they establish the penalties, they establish the compensation as well. For example, if I am a state and I have caused damage in my jurisdiction, and in my jurisdiction it has basically affected the other countries as well, the other country basically has a right to ask me for the compensation as well. This is the principle of preventive action. I have just discussed this to this point. I'm going to be discussing about a case law here. I'll cite the case law. You can write it. But if I get a time, I'm going to be discussing about that later on. If I don't get a time, so just go to the Google, search in it, um, and you get to know like how does it work. And in these preventive actions, basically, what do they do? The countries basically have a little bit of what do you say, the agreement with each other. Okay, if I have caused this problem, we will settle this. We won't go to the International Court of Justice. We won't go to international tribunals for it. Let's try to settle it. The case is Nauru versus Australia. It's 1992 case. It's Nauru versus Australia. It's a case. Basically New Zealand, United States, Nauru, and Australia were a part of the treaties when Nauru didn't get the independent status or didn't get the sovereign status, and it didn't become the sovereign state at all. It's of 1992 case, and that case is all about the rehabilitation of the phosphorus land and the phosphate land. Australia was of a view like, okay, whatever we have to keep it. Nauru was just saying, okay, if you are saying that this particular natural resource just comes to you, so why, if I have got the sovereign state, so why don't I have an access to the natural resources there? Why don't I have an access? So then the actually conflict happened, and United States was involved in it because that was the treaty that ever happened between New Zealand, United Kingdom, Australia, and Norway at that time. What happened at the end? That United international the basically the problem went to the International Court of Justice. International Court of Justice, after assessing everything, basically said, okay, they accepted certain objections of Australia, but they accepted certain objections of Nauru as well. But before the International Court of Justice could have made a conclusion on it, the Nauru and Australia both had a settlement with each other and resolved the problem. That's why I mentioned about this case law in this principle of preventive action, so that you can get to know, like, again, I'm going back to the first point when I discussed about the Article 38(1) of the International Court of Justice, that about the elements, and how do we derive the international law. So this is about the international jurist things, and this is all about the generalized principles of international um, countries, uh, by the civilized nations and all that stuff. Okay, a fourth principle of international law that is basically greening to protect the environmental law is the precautionary principle. This principle is extremely important. It's still developing. Always just keep in mind, like, it's still developing. This precautionary principle is developing, and it will be developing, as I just mentioned earlier in the start of my presentation. It will be developing. It will have to, because the thing is, even if we pass away one day, even if we die, there will be so many other our next generations who will be discussing about the precautionary measures. Okay, what precautions can we take? What precautions can we take? Not to cause damage to the other environmental state and all that stuff. This is extremely very important. But this precautionary principle is a little bit different here. The point is, international laws say, in the case of any emergency, in the case of any severity, in the case of like serious problems or the irresistible damage problem, you don't have to wait for the scientific research. Don't wait for the scientific research. To say like, I don't have an access to the good technologies and I don't have an access to the scientific technologies, which is with the industrialized countries or which is with the developed countries, this is not an argument. This is not an argument at all to say like, that's why I didn't protect the environment. No, whatever you have, whatever states have, according to their capacities, according to their advancement, and all on and so forth and so forth, yeah, they have to protect the precautionary measures. They have to protect the environment. They have to take the precautionary measures as much as they can. Now, I mean, any one of you would have asked me this question, but you guys didn't ask me. But how much precaution do we need to take? What's the threshold of it? What's the threshold? I mean, if I'm saying you have to take precautionary measures in the case of damage, in the case of serious damage, How would you know like how much damage is the threshold to protect the environment? Any one of you, any one of you, how would you get to know? How would you get to know like this is the damage now we have to protect? Is there any threshold for it?
I think, despite of measurements and experimentation, we should go for the precautions first, and then look for the changes in the environment. If it's declining, then it's clear that we should take that much level of precautions, and these are the borderlines.
Exactly, exactly. Very right, very right. Thank you so much for your active participation in it. It's very right. There were two conventions in the world that actually discussed about this point. Like, no, we don't know. Yes, Malik Suhaib, yeah, yeah. Any
Okay, ma'am, you
question,
just said
please?
about the precautions, like what is the threshold? The question here, like I would say precautions differ person to person. For example, if I'm a common man, I am just using bike. My precaution would be a different from another person who is using a bicycle or who is using a jet. For example, like in 2024, there is a celebrity Kim Kardashian. She went from
Mm-hmm.
LA to Paris just to get a piece of cheese.
Mm-hmm.
It was her precaution, like she didn't disrupt it so much. So what do you think? What could be the threshold?
Yeah, let me just tell you about it. You're talking about person. Obviously, you have given me kind of like um, an example that actually is talking about the people. We're talking about the states. Obviously, that actually comes to it. As I mentioned in the start of this principle precautionary measure, I mentioned one thing like it's still evolving, it's evolving and it will be evolving. And then I said like even if we pass away, our next generations will be dealing with it, that they have to take the precautionary measures. Both of you are very right. So what happened, there are two conventions in the world that has ever discussed about this precautionary measure. In 1992 sorry 1999 1991, Bamako Convention is BAMAKO. Bamako Convention said that there is no need of seriousness, as you guys are talking. We have to take the precautionary measure, come what may. We have to take it to protect the environment, to protect the other states, and all that stuff. Your both of yours point is basically hitting the Bamako Convention of 1991. It was stated there. But then in 1992, Convention for the Protection of Marine Environment, because keep in mind one thing, apart from the noise pollution, apart from the air pollution, okay, states like your call ends in 15 minutes. Um, do we have an excess of like more time so that we can have a discussion?
For that, we have to create another meeting, but for this meeting, we have only 15 minutes left.
Okay, 15 minutes, and after that, I think it's better to have another session. So we'll
Sure,
just
sure.
everything up here because I don't want to. I mean, we have so many amalgamation of so many things here, and I just want to leave everything in between. Okay, so in 1992, Convention for the Protection of the Environment of Marine said like there it shouldn't be just a mere damage; it should be more than a mere damage. So in this 1992, the Convention for the Protection of the Marine Environment, there were so many jurists who actually discussed this question. Okay, so how would you say like this is a threshold? If you talk about like there should be more, it should be more than mere damage. What does it mean by it? So then obviously this convention was for the marine environment. So they said like water comes in it, the biological biodiversity comes in it, so many things come in it. And still, after that, in 1992, after this treaty, when they discussed about like there shouldn't be just a mere damage, it should be more than there should be more seriousness. International jurists and international scholars all over the world are still talking about it, like how much precautionary measures we need to take. But still, all over the world, states from all over the world are discussing about basically complying all the rules and regulations, keeping in mind about the 1991 Bamako Convention that actually states that there is no need of seriousness. We have to be prepared ourselves as come what may so that we don't have to face so many problems, and we don't cause any violation of the international law by damaging the other country's environment and all that stuff, right? Okay, come to the next principle. Within 30 minutes, I think it's better if we can complete the next principle, then we'll have another meeting. It's the duty of compensation. It is also called no harm principle. No harm principle, NOHARM. It's no harm principle. What does this mean? That we know like states are responsible to protect environment, not within just their own jurisdiction, but in other countries' jurisdiction and in the areas beyond their national jurisdiction. It's basically the duty of um, all the states. And if they fail to do it, it means that simply it's the violation of international law, because these are the principles of international law, and these principles are not something like I am talking about it or maybe I have made. No, these are the principles which have been derived from international customs, international conventions, international general principles of law recognized by the civilized nations, by the highly qualified jurists, and the international tribunals findings. So this is not something like maybe you and I have prepared these principles. No, these are the principles which have been derived, and if you violate these principles, simply this means that you have violated the principle, you have violated the international law. And if there is a violation, what happens? There's a compensation, there's a penalty. It's the penalty that you have to pay. This is also a principle of international law. So in this principle, uh, there are two things. There shouldn't be any wrongful conduct on a part of a state, or if the wrongful conduct has happened, so what you have to do next, you have to basically try to re-establish the thing into the same condition as it was existed before, right? So uh okay, somebody texted, I think somebody. Okay, right. So uh, when there are wrongful conduct, so you, first of all, states have to try to re-establish the thing, and if they don't re-establish the thing in the same way as it was existed before, so they have to pay the compensation of it. And how do we basically get to know about it? There is another case law which I am mentioning right now. Yes, Avas, I've got your question. It's a very good question. We're discussing about that. It's basically we are coming to it. The next principle is all about the question which you have asked, and we'll get the answer. Okay, so the case law which I mentioned in the duty to compensate for harm, or the no harm compensation, is Permanent Court of Justice in case German interest in the Polish Upper Silesia. Um, this is about the German country. I'm going to give you the case citation. You can have a read of it. It's FRG versus Poland. So you can have a read. In this case, it was discussed about the reparations. Reparations means that you have to pay back something in return if you have caused the wrongful conduct. And how you have to do the reparation, you have to do the restitution of it. Restitution means that you have to try to re-establish the thing which was existed before, but as you are unable to do it, so you have to pay the compensation. Now a question should have come in all of yours mind is like, how much reparation, how much restitution? It depends upon a state, there is no doubt in it, it depends upon a state. But as far as this is environmental stuff, how would you get to know like this environmental damage should cost this thing? If I'm talking about plants, I'm talking about the restitution, I'm talking about the re-establishment of the thing. If everything is destroyed, if the ozone layer is depleted, can I re-establish it? No, I can't re-establish it in the same way as it was existed before. Even if I can, even if a country has the resources, it is not economically feasible. Even it's America, even it's China. If that was the problem, had this been the problem, the whole world would not have been facing the climate change problem right now. Though they are working law on it, a law on it, but still there is a problem in it. Still there is a problem. So it depends upon the, so the international law basically has left this thing on the states, on states all over the world who are the signatory parties to the United Nations Charter, that you have to basically, this is up to you, that how much damage has been caused to your state. It is up to you, and it's completely acceptable. That's why I've given you an example of the FRG versus the Poland, when when in this the compensation was asked by the people. And there is a lot of examples if you search on it. Okay, Rian, before I go for that, I think it's better to just send the another email so that I can have a discussion on it. I don't know like how much time is left now.
Only 8 minutes left. Maybe Daniel might have sent you the new link.
Alright, let's check myself on that. Hold on for a moment. Okay. Let me just try to connect here. Is everybody getting our points, or like it's just simple meeting, simple lecture? Turn off your turn on your mics, please, everyone. Okay.
Participants, you may turn on your mic and share your views. Are we
Are you
getting the point?
getting something, or like it's a little bit difficult because it's still evolving, but yeah. Okay, let me just turn off it and let me just connect to another meeting, yeah? I'm just gonna get
Sure,
back
sure.
with you. Yeah.
The meeting link.
We'll try to conclude this in 30 more minutes and then we'll have some questions. Yeah.
Sure, ma'am.
I think we just gotta wait more for some more people because I think they're still joining.
I think we've got plenty of members
So
to
should I
start.
start? Should I start then? Yeah.
Sure, sure.
Keep recording it if anyone misses something so that they can um have an idea to read that later on or listen to it.
Yeah, it's been recording.
Okay, where we were. Any one of you, let me know like what I was talking about. We are all fasting, if I'm not
Madam, you
wrong.
were
Yeah, and
madam, you
I
were
am
talking about the
it's it's morning here and I have to spend the whole day ahead and I've spoken so much where I was.
if I'm not wrong, madam, you were on the Poland case. You were talking about that case.
Yeah, yeah. After that, did I say something else as well? It's okay. What I just told that we are gonna discuss another principle. Let's go to the last principle. Not the last, second last principle. This is the principle of common but differentiated responsibility. Principle of common but differentiated responsibility. It's a very interesting topic, and Avas actually asked this question, and this question is basically dealing with this question. Avas, just have a focus on it. The protection of environment is a common challenge, obviously, to all the countries all over the world. So there are two constituent elements in it. That is, first of all, there is a common responsibility of all the states all over the world to protect the environment. But it's common. It's common. for all the countries. But then there is an elucidation of the different circumstances of the state. Elucidation of the different circumstances of the state. What does this mean? The industrialized countries in the world have contributed more to the environmental damage. Do you guys agree on it? Industrialized states, developed countries, America, China, Russia, Japan, well, even the countries who look like they are begging for something, they are actually very industrialized countries. United Kingdom itself is got the veto power. It's all just about industries. If you come to London, if you just see London, so it's all just about industries. There are a hell of industries here. So industries are basically contributing more to the environmental damage. At the same time, developing states don't have that much capacity and they are less advanced in it. They are less advanced in it. So it's a little bit elucidation of contradiction here. The industrialized states are contributing more and developing states are basically not that much advanced. How it's going to work now? They are not stopping from being industrialized, like more and more, more and more, more and more. There's a competition with the other countries. America has a competition with the China. China has a competition with Japan. Japan has a competition with all over the world. Pakistan has a competition with India. India has a competition with Pakistan. Bangladesh has a competition with Sri Lanka. Sri Lanka has a competition with Nepal. I mean, it's been happening. Nobody is stopping. Nobody is stopping from being industrialized day by day, day by day. And the developing countries are not that much advanced. So the international law here says, if you are contributing more to the environmental damage, you have to protect the environment. You have to make those strategies that actually works to protect the environment. At the same time, the developing countries, there is a rule that if you are not developed, try to be developed. As I mentioned earlier, there is in the principle of preventive measures, preventive action, that in law we say, like, not knowing law is not an excuse at all. Not knowing law is not an excuse. The same is the principle of international law. Not having a scientific technology is not an excuse to not protect the environment. Still, you both have the common responsibility. Even if you have the less advancements and all that stuff, it means that your country is, for example, if we talk about Pakistan here, I mean, there are so many people from Pakistan, if I'm not wrong. Pakistan, I'm not saying like it's a developing country, it's still an underdeveloped country. Make sense? If it's an underdeveloped country, it means that it has contributed less to the environmental problem. If it has contributed less to the environmental problem, it means even though they don't have the scientific research, scientific strategies, scientific instruments, still they can work on it. They can work on it. So we'll come to the question later on, please. And as far as the international, so the industrialized states are concerned, so if they have contributed more, it means that they can have an access to the scientific research, scientific technology, scientific machineries, etc., etc., etc. And it's been happening. Let me just give you an example of one thing. With the level of sea level rise, I mean, there's a rise of the sea level all over the world. So with the sea level rise, for example, if there is a small island and with the sea level rise, I mean, a lot of water comes into the maritime jurisdictions, makes sense. And if it's coming to the maritime jurisdiction, so the international law and there are a lot of predictions on it. My thesis actually was on it. And if it is so this means like islands will vanish away. What about the human rights then? So how we have to protect it? And what about the underdeveloped islands? And what about the developed? UK is a developed island. So what they have created, if you have a problem of a sea level rise, they have created artificial lands, more artificial islands as a barrier so that they don't get flooded by the sea level rise. And if there are small islands, so they are still making a little bit, I mean, small barriers. For example, if you have read about different bays, bays in the if you read about a little bit law of sea, so you get to know about it. In the bays, they actually put a little bit barriers or instruction, or they instruct a little bit barriers so that they don't get flooded and the sea level rise issue don't get that much complicated in it. So it's the principle of common but differentiated responsibility. Both have a common problem and responsibilities are also the same, but it varies from a city to city, as somebody of you actually discussed about that it varies from a person to person. Same, it varies from a state to state. And here we get to know about the 1992 Convention on the Protection of Marine Environment, which I discussed about 1991 Bamako Convention, that jurists are still working on it, but international law has given a principle that though it's common, but it's still different. There is a still differentiated responsibility on it. Makes sense. Now comes to the last but not the least, it's a principle of international law that's basically protecting the environmental um, problems, and that is the principle of sustainable development. If you, any one of you, is familiar with international law little bit, any one of you, let me know what does this mean by sustainable development, please. Sustainable development, have you guys ever heard about this word before, if you're a student of international law?
Yes, ma'am. We have heard this word sustainable development, development which can continue. It is not like this that today we invest and tomorrow we come and we say there is no road, there is no bridge, there is no dam, so there is no city. So we have to focus on something which should last for more time. That is sustainable. Thank you.
Exactly. Very right, very right. Thank you so much for it. Sustainable development means that it's still working. There are three principles of sustainable development. Let me just more elaborate for you guys for your future. The first principle under the main principle of sustainable development is intergenerational equity. Intergenerational equity. This means that every generation has the responsibility to leave the inherit of the natural resources for the next generation. It's our responsibility. It's our responsibility to protect the environment. And once we pass away, we are basically, it's a legacy. And we are basically inheriting all these, whatever we have with us as far as the environmental stuff is concerned. We are basically inheriting this to the next generation. It keeps on going. This is called intergenerational equity. Equity means like it should be equal. It should be according to the laws and regulations. We don't know like what laws are going to be coming in the next a few years, or maybe 10 years, or maybe 20 years, or maybe 30 years. We just don't know about it. But what we know is that it's a legacy, and we have to keep it continuing. We have to just keep it straightforward, so that the people from all over the world, so the generation who are coming after us, we have to relish from the natural resources, whatever we have kept. So it's being a human being, not a state. I mean, state comes with the people, and with people, basically, we all have a responsibility to protect the environment as much as so that we can inherit this to the next generation. The second is the integration of environment and development. Whenever we talk about environment, obviously, with the climate change, with the green gas emissions, with ozone layer depletions, with different um, problems, with the marine problems, with the there's so many things in it. But the main thing which is here, which is very important, is that we have to keep ourselves up to date. We have to, if there is a problem of the environment, we have to be into the scientific kind of like research. That's why more focus has been put on the international laws. More focus has been given to the international environmental law. And if you I'm not sure about like Pakistan or India, but what I know about the foreign countries, there are different departments in the universities who are basically just conducting the research. There are PhDs on just the scientific research of how can we protect the environment. And people are doing LLB in it. People are doing, sorry, LLM particularly in it. People are doing PhDs in it. People are becoming a part of research in it. In my university, actually, it was a complete department that was just doing the research on that particular thing. So basically, they are complying the rules and regulations and the principles of international law, which is extremely very important here. And this is the integration of environment and development. The very last principle of sustainable developments, um, the core principle is the sustainable use of the natural resources. This is really very important. Just look at the idea and the concepts of the United States of America. I'm going to give you an example of it. In 1893, United States of America basically proclaimed rights to protect seals from destruction. Seals, I mean, the seals are the one who are like in the high seas, seals. In 1893, when international law was in the evolving process and it wasn't developed clearly, United States of America has a thought on it at that time in 1893 to protect the environment, and they proclaimed rights. Still, United States of America has a right to protect the seas from the destruction. This simply means, I'm giving you this example. I mean, just look at the thinking of those countries, those developed countries. I'm not going to go into the international relation stuff, so what I like about them or what I don't like about them. But what I am saying right now is that just look at how much foreseeable insight these states have. International environmental law was never existed at that time, and that was the time when United States of America discussed about to proclaim rights to protect the seas from destruction in 1893, and it's still United States of America is proclaiming those rights. So, I mean, there are a lot of examples. There are a lot of examples on it. I've just given you one example, and there is a term that is basically used. There is no particular word of sustainable development in all international law. There is no particular definition of it. But how do the international jurists describe it? By saying wise development, judicious, expeditious, sound, environment, useful. They use these kind of like words, but they use the word sustainable, but there is no particular definition of it. But it's also described by the international customs, international principles. This is the convention, and I've given you an example of 1893 when the USA proclaimed the rights of the seals to protect the environment. This comes under the generalized principles of the international law, accepted by the civilized nations, and it is a custom as well, and they have different conventions on it. There becomes a convention, and there becomes an international tribunal stuff in it, because no international tribunal, international court of justice has ever objected this proclaimed right as been ever stated by the United States of America. So these were basically the principles of international law, which actually is describing our topic of the greening of international laws to protect the environment. They are working on it. So as I mentioned earlier in the start of my presentation, that I didn't go into the very detailed of like the different treaties and all that stuff, but I'm going to give you a little bit view in just 12 to 15 minutes of different important treaties. Have a note of those treaties. That's going to, well, there are so many treaties. Just keep in mind one thing, there are so many treaties who are working for the international environmental protection, but I have actually underscored few of them, which is extremely important. So first one, which I'm going to discuss, is called 1992 Triplet. It's basically an amalgamation of 3 different treaties, which is very important to discuss right now here, as I'm discussing about the international environmental law. So the first treaty is United Nations Framework Convention on the Climate Change, which is called UNFCCC. Whenever anybody is talking about the environmental law, they do discuss about this United Nations framework. It was ever existed in 1990s, basically 1991, 1992, but not above 1993 and all that stuff. What's the main purpose of this basically treaty is to protect the human beings from the climate change. And those climate change has basically caused the problem because of human activities. So their main basically target is to stop those human activities within a state within one state's jurisdiction, within other states' jurisdictions, and in the areas beyond national jurisdiction, so that to protect the human activities. And how do they access it? There are different conferences of parties, and it is conducted basically annually. What do they do? They discuss about like what's going to happen next in 10 years, in 20 years, in 30 years, what are next goals, how do we need to, they basically establish task force, they basically establish the financial uh, there is a different department as well that actually discusses okay how much is going to be funded to different countries. Developing countries are basically being funded by the to protect the environment. But the problem with us is that, and the problem with the international, not the international media, but the problem with our country's media is that we just keep on talking about Imran Khan, we keep on talking about Nawaz Sharif, we keep on talking about Mr. Modi, we keep on talking about Trump and about Putin, but we don't talk about like how much in how basically the developing countries are being funded by the international communities. They are being funded by the international communities, but as far as the corruption is concerned, so I mean, how can you say, corruption has basically halted everything in a very complex situation. So this is actually happening. And if you have a little bit, I mean, time to discuss about these ideas, like how they're being funded internationally and to all the signatories countries of the United Nations Charter, you get to know about it. Okay, so Paris Agreement basically is also existed in UNFCCC, and they are actually discussing about so many things in it. Okay, second convention, which comes in the 1992 triplet of the conventions, is the Convention on Biological Diversity. Biological diversity, everything comes in it, but women and indigenous people come more in it. Now, can I ask any one of you, if I talk about the Convention on Biological Diversity in relation to women and indigenous people, what does this mean, please? Any one of you? Anyone? Convention on Biological Diversity in relationship to the women and indigenous people.
Come on, participants, turn your mics on. Let's contribute to this session.
Uh, a woman, maybe because they give birth to the generation, and we have seen, we have witnessed in our part of this world that
Mhm.
they are not given the equal opportunity, and we have seen they are being deprived. So maybe UN is also given special importance to women and the biological diversity. Maybe.
Okay, I've taken your answer. Okay, let's go to the other, other participant. It's Naveed Malik. Yes, Naveed.
Am I audible?
Yes, perfectly. Just keep on going, please.
Include women in the decision-making process. So basically, this is it.
This is something like we are discussing. I think you guys are discussing about the domestic stuff. What does this mean by biological diversity in relation to women and indigenous? Okay, can anyone let me know like who are indigenous people without Googling on your cell phone, please?
Yeah. Indigenous people are those people who are
Mm-hmm.
always son of the soil, who have not migrated from anywhere else, and they have and they have the fear of extension as well. They are called the indigenous people.
Okay, so how are you going to relate the indigenous people to the Convention of Biological Diversity? Yes, Masoud Khan.
Ma'am, I think so. Indigenous people means like the people who lived in Afghanistan and America came there. So America destroyed all the things, but indigenous people are the original inhabitants of that place. Means like Afghanis.
Hmm. Okay, let's don't talk about indigenous people. Let's discuss about the connection of indigenous because we are at the end of our topic today. What does this mean by indigenous people and the women as far as the Convention on Biological Diversity is concerned? How is it so? It's very simple. I mean, just brainstorm a little bit more.
Let everyone share his view on this thing.
Please, yeah, it's
Let's
just
see. Let's see.
seminar. I mean,
Come on.
I'm not marking, I'm not gonna mark anything for you guys. It's just a seminar. I mean, let's have a discussion with all of you face to face. That will be like, you get to know about it. I actually learned about it yesterday, to be very honest. That's why I'm a little bit curious about it. I never knew. I mean, I'm working on my PhD right now, and I mean, I've a lot of experience at the law firm, but I never had an idea of this thing, and I just came to know about that yesterday. So that's why I'm having a discussion with all of you guys. It's a new thing for me as well, so why not sharing?
Come with us. Come.
Uh, I
Okay,
think it is.
yeah, yeah, yeah.
Am I
Yeah.
audible?
Mm-hmm.
Yes.
Yeah. Please.
Regarding this topic, my view is the indigenous people are the one who are the ancient inhabitants of a
We
particular
know,
area. Like we
we
had the.
know, we know.
I'm just clarifying my point. I'm just
Mm-hmm.
clarifying my point coming to the convention. So convention is like there should be biodiversity. You should not in any way to diminish their population.
Exactly.
We just saw this
Exactly. That's the point. That's the point. That's the point. As time is very short, so let's go to the conclusion.
exactly.
Thank you so much for it.
Okay.
We don't have
Okay.
to let them extinct. As far as women are concerned, all over the world, women population has contributed more than men to the agriculture production. It's a very, very, very new thing. In the agriculture production, in the production of the land, not just the agriculture, in the water resources, I mean, they have worked more than the men. That's why to protect the women and indigenous people is really, really, really very important, so that the cycle of the ecosystem keeps on going, keeps on going, keeps on going, and it don't get extinct at all. That's why convention on the biological diversity is working on it. Okay, so the last convention which I'm going to be discussing here is the United Nations Convention to combat desertification. It's called CBD. UNCD. UNCD means, like, you have to just keep in mind like how to manage your land. You have to get to know about the forestry. You have to know like what's the planning of it. I mean, if there are more forests, so there will be less problems to the ozone layer, there will be less problems to the climate change. That's why every country and every second person keeps on discussing about the planting more and more in it. So these are basically the 1992 triplets. Okay, Rian, can I ask you just one more question? How much time is left for this session so that we can conclude this and we can have some question and answers?
Ma'am, we are running into a new meeting, so we have plenty of time as per this Google Meets, but we have already taken our time. So it's up to
Exactly.
you now. It's up to you now.
Oh, actually, there are so
You
many
continue.
treaties. I mean, as much as treaties, I'll keep on going. There is a Paris Treaty. There is Kagili movement. I mean, there is HFC movement. There is I mean, Paris Protocol. There is Montreal Protocol. There is Tokyo
Stockholm.
Convention. So there is Stockholm Convention. There is the World Heritage Convention.
So let's just keep it to the request
Exactly.
of participants and interest
Yes.
of participants. If they want us to continue or
Yeah,
we
so
should
yeah, it's
come
all
to the
done
question
from
and
my
answers.
side. I mean, if any questions are there, so you can ask me questions. So
Sure, sure.
yeah, please.
Ma'am, I have a question.
Yes, please.
Ma'am, it's a simple question.
Mhm.
What is the rule of ICJ when America, Israel, like Great Britain, like Russia, destroying the environment of countries, the environment of world, like recently in Palestine, in Afghanistan, in Iraq, Iran war, in
Okay,
in
this
South
is
Africa.
exactly. Do you have raised a very good question? There is a convention on it. Let me just tell you this convention. As far as we discuss about as time is very limited, given the limit of the time, I didn't continue with it. There are so many conventions actually which I just wanted to discuss, but I won't be discussing here right now because then the session would be extremely long. There is a convention which is called Brussels Convention, and there are some nuclear, obviously, with the there's so many ultra hazardous complications which are happening all over the world. United Nations General Assembly have so many treaties on it, but as far as the international law is concerned, international environmental law is concerned, when we have the nuclear bombardment on any country, obviously international environmental law straight away keeps in contact with it. But do you really think like when the war is still ongoing, would the environmental international environmental law will jump into it and would ask like there is a problem to the environment? No. People would be discussing about to save lives of the people than the environment. There is an international environmental law, but if the war ends, whatever has been happened to the whatever damage has been caused as far as the nuclear risk is concerned, according to the Brussels Convention of the 1992 as well, if I'm not wrong, it's 1992 or 1993. You can have a read of it. So this is actually discussed in the World Heritage Organization after the Stockholm conference. They have actually discussed about this idea, like even though there is a risk of the nuclear bombardment and when the environment has been completely damaged, but we have a priority of everything. We prioritize everything. When the war is still ongoing, so our target is not to protect the environment, our target is to protect the people, to save lives, not to save the environment. That's the priority. But if war has completely finished, I mentioned about the principle. It's the principle of no harm. Then the no harm principle applies in it, which actually says that you have to go for the compensation, you have to go for the reparation, you have to go for the restitution. So it's up to the state whether, okay, if this is my home and you have done something wrong to my home, it's up to me now. I've been suffered from the damage which you have caused me, it's up to me now. Do I ask you for the reparation, or do I ask for the compensation, or I say, okay, it's okay, perfectly fine, I have so much, I'll make something new for me. It's up to the state. So the principle of the no harm applies to it, right?
Yes, ma'am, but why Israel are using white phosphorus that is demolishing the state, that is demolish the Gaza, and they are using nuclear reactors like phosphorus bombs and a
Exactly.
lot of many others. And America is doing nuclear मीन्स अमेरिका जो है वो पैसिफिक ओशन में जो है वो अपने न्यूक्लियर रिएक्टर्स को चेक कर रहा है। तो क्या मतलब अमेरिका के पास इतनी सारी जगह कम हो गई अमेरिकन स्टेट में जो इतनी बड़ी कंट्री है कि वो
See,
अब पैसिफिक ओशन की तरफ आ गए?
exactly. Now, I would basically answer your question to another point now, as far as the harm is there. International principles are definitely there. But if you have a little bit interest in the international relations, you would get to know about an theory of realism. Just read that theory, you get to know about the answer. Realism, basically, there are so many countries all over the world. Some countries try to resolve the situations in a very amicable and very delectable manner. What they do, they say like, we have to go for the I mean, not the realism, but we have to go for and other areas of the international laws where international relations where there would be amicable situation. They didn't go for the realism. Realism means state thinks that I have the power to do whatever I have to do and whatever I can. America, Iran, you have skipped Iran as well. Actually, we all are actually in a support of Iran. That's why we skip Iran and we keep on hitting Israel and America. We haven't discussed about Korea. We haven't discussed about China. I mean, have you seen the artificial intelligence problem, environmental problems all over the world? I didn't discuss about that because time is very short. Otherwise, it's a very, very, very long discussion as far as international law is concerned, and we can have lengthy more discussion on it. But still, as far as your question is concerned, that why is it so? It's just because of this state of the mind, and that's their state of mind is realism. United Nations, international law is there. Always remember one thing whenever you are discussing about international law. International law is not, I mean, the countries are not bound by international law. It's not coded anywhere. It's not bound by international law, but they are meant to be bound by international law as far as the customary international law is concerned. Always keep in mind one thing. That's why there are conventions, there are treaties who have said like there would be compensation, there would be obligation, but still there is a problem, and the problem is in the part of both the sides, on the victim as well, because they are not raising the problems of the environment, they are raising the problems, as I just mentioned earlier, that when the war is ongoing, as far as the international humanitarian law is concerned, as far as war is ongoing, you would definitely go to protect the lives of the people rather than to protect the environment. But if war has been completely ended, then the victim state has a responsibility to ask for the compensation and the reparation. But because the international arena and international stuff, international relations have been just amalgamated into this kind of like sense that they have not been given any opportunity to think about something as well. If you think about Palestine right now, do you really think that they would be thinking about environment now? They would not be thinking about environment. They would be just thinking about another area of the law, of the environmental law, which is not our topic of discussion today, but still I'm telling you, they are basically just discussing about to save the lives of the people, and international relations theory realism comes into your question if you have a read of it, right? Okay, next, if we have a time.
Okay, let's just take the last question from
Yeah, please.
Asim. Please.
There is no female in
Navi,
it. Is it so? They
we
didn't
have
ask me.
female participants, but I think they are hesitating to turn on mic.
I'm not hesitant to give the lecture.
Let's just motivate them first.
I have seen Isha is there. Isha Amjad is also there. Nida, Noor. Amen. Okay, yeah. What's the question? Last question, and then will be just the ending of the topic, please. Yeah.
Navi,
जी आई एम
Yes.
ऑडिबल मैम
Yeah. Please keep on going.
मैम अगर हम आजकल की सिचुएशन में बात करें तो नियो लिबरलिज्म आईआर की एक बेसिक थ्योरी है जो
Exactly. Yeah.
इसी पे ही बात करती है जो स्ट्रेंथनिंग ऑफ
Mm.
इंस्टीट्यूशन यही सारे फिर आगे जाके जितनी भी ट्रीटीज हैं पेरिस एग्रीमेंट या जितनी भी कॉन्फ्रेंसेस हैं
Yeah.
यूनाइटेड नेशन जितनी भी इंटरनेशनल ऑर्गेनाइजेशन है वो इनको आगे जाके इम्प्लीमेंट करेंगे जिस पे लिबरलिज्म सारी बात करता है तो ये तो
Yeah.
अब हम देखें जो इसका चैंपियन था लिबरलिज्म का यूनाइटेड स्टेट्स उसके अब देखें जो कंटेम्प्रेरी में ये ट्रम्प साहब ये तो इससे सारा विदड्रॉ कर रहे हैं वो पेरिस एग्रीमेंट से भी निकलने का सोच रहे हैं वो आईएमएफ बाकी भी
Yeah.
जितने ऑर्गेनाइजेशन है
Because they
लेकिन
don't follow neoliberalism. They follow realism. That's why.
नहीं अब ये कैसे इसका मैं फ्यूचर पूछ रहा हूँ कि ये फिर कैसे होगा ये क्लाइमेट चेंज हम कैसे करेंगे ये
No,
जो हो रहा है
climate
इस पे हम
change.
कैसे मतलब
See,
इसके
the
पीछे
climate
बॉन्डिंग वो
change is a different thing.
इसके पीछे बॉन्डिंग क्या होगी अगर कोई वायलेट करता है
Okay, if that's why I asked you to have a recording of it. It's up to me. It's up to the state whether they want to withdraw from any kind of like convention or treaties and all that stuff. But still, keep in mind, even if it would become a signatory part of the any convention, customary international law still in contact with it, and United States basically has a problem to be a chaudhry of every country. So I'm so sorry for it. I'm just gonna give you an example that they think like they have ruled the whole world and they're the one who have to rule the whole world and all that stuff. But still, if you go to the ICJ website of the advisory opinion of the international tribunals, international jurists, international arenas, if you go about the settlements of the arbitrations and all that stuff, you would get to know about one point: the United States has been penalized and compensated so many times more than any other country in the world. And they have actually paid the compensation. They have paid the compensation. They have been penalized by it. But the thing is that they don't follow the neoliberalism. All in all, they just follow the realism stuff. But don't confine yourself just to the United States of America. United States of America is just the one country. Go to the Africa. There is an African charter on the humans and the people's right. Oh my God, I just love this African charter, because they have done so much in the regional level that you can't even imagine of it. If you go for the Montreal Convention, and as well as one more thing, the Paris Convention, even though they are saying like we're just going to withdraw the Paris Convention, but still international customary law is going to be in contact with it. And if they violate any principle of international law, whatever we have discussed in our today's lecture, they are going to be put under hot waters, and they have to pay the consequences of it. They have to pay the price of it. So don't ever think about it like they won't be. I mean, the other countries, you can't say like America is the. I mean, there is. It's just as. It's just. How can I say this? I mean, why every time we just keep on going for the United States of America? It's just a country, but don't ever underestimate your rights as well. Don't ever underestimate your
मैम ये
other
मेजर
countries'
कंट्रीब्यूटर
rights
है
as well. Sorry.
मैम, ये मेजर कंट्रीब्यूटर है इन सारे जितने भी ऑर्गेनाइजेशंस हैं, इनको सबसे ज्यादा फंडिंग भी यही करता है। तो अगर कोई
Yeah.
कंट्री अब रियलिज्म की बात करें तो वो कहते हैं देयर इज नो मोरालिटी इंटरनेशनल रिलेशन। तो कोई कंट्री क्यों दूसरे कंट्री का ख्याल करेगा? जिस तरह से डेवलप्ड कंट्री हैं वो अपनी
But they
प्रोग्रेस
have
करते
to.
हैं,
You know,
इंडस्ट्रियलाइज
see,
होते जा रहे हैं।
your question is that why we would, for example, if you and I have, if you Naveed, you and I both have the land resource, land agriculture, just say land agriculture, let's make it quite simple. If we both have this thingy, and we both have the resources, equitable resources to it, so why, if you violate something and if I violate something, it's up to you now. Would you be asking me this question, like why you violated? Don't ever think about it like if the United States of America or if any other country is going to violate the international environmental law, they're not going to pay for it. No, they have to pay for it, but you have to ask for it. See, there is a principle of international law, there's a no harm, but international laws principles are definitely binded by all the states. But it's up to me now. It's up to me whether I ask for you for the compensation or not. If I say, look, okay, I just forgave you, it's completely finished, then you can't say I made a mistake, I did a mess with you, Miss Binish, but still you are not asking me for this. No, it's up to me now. Same is the state with is the condition with the states as well. States know about their rights, states know about the principles are there. The implementation has been left to the states now, has been left to the states. As far as your question, another part of the question is concerned about they're the major contributors to the industrialized. Obviously, that's why there is a climate change problem. That's why now international jurists and international arena has basically taken more attention and more stress onto this question to resolve this problem, like why it's been happening. And now US, not just USA, but the other countries, the United Kingdom as well, China as well, though they are the major contributors of it, but they are still working on it. But as I just mentioned earlier in the very start, that international environmental law is basically evolving process. If we are talking about these principles now, after maybe 5 years or after maybe 10 years or after 13 years, there would be more principles on it. So as far as today's thing is concerned, they are working on it. And you know, we also think about it like there has been no work going on. A lot of work has been going on, but this area of international law, environmental law, the problem is that we just pinpoint the negative point, but we don't see like what's been happening as well. I'm not taking the support of these industrialized countries. Obviously, these industrialized countries has created a lot of mess to this world. I mean, they've completed a lot of mess. I mean, there's no doubt in it. I'm not denying the fact, but at the same time, We can't ask them not to be industrialized. Who we are, who we are. We developing countries can't ask them not to be the industrialized states in the world. If they are working hard, so why can't we? We have to. But now, how they have to conduct this process, international law is definitely there. The international law basically is always there. I think my voice is gonna be okay. Now it's perfect now. So I hope you got my point that the problems are still there. There are a lot of treaties, customs. Everybody is actually working on it, but uh, just don't say like, it's up to me now. Being a state, it's my responsibility to ask for the compensation. And if I don't ask for the compensation, international law is not going to ask me that, Miss Beanish, why you didn't ask for the compensation? You were allowed to do it. No, it's up to me now. So if any country is not asking for it, that's not the fault of the USA. That's not the fault of the industrialized countries. That's not the fault of the international law. It's up to the states. It's up to the victim state. And implementation is already there. Otherwise, there wouldn't have been any conventions. There wouldn't have been the cases that would go to the International Criminal Justice. So if you go to the International Criminal Justice website, go for the environmental laws cases, you would get to know like there are plenty of cases that are pending that have been concluded since 1990s, before 1990s. It started in 1960s. So international environmental law is basically there, and it's been implemented. And how you say like it's not been implemented and implementation is left, because you've just been pointing the negative point here. I'm not saying that, I mean, you have a right to ask this question, but we have to be completely realistic in this sense. We didn't have to take a support of, and every time whenever I just give lecture, we discuss about Israel and Palestine in every way, even if it's environment, even if it's, um, um, humanitarian, even if it's human rights problem. In my last lecture, I think we discussed about that. Somebody asked me this question as well. So if we talk about Palestine and Israel problem, please, 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 their lives are more important than environment. I would conclude this way, right? Any more question or anything left, or if everything misunderstanding is still there, I really apologize like if I didn't make you guys completely understand of anything. I try my level best of it. If you still have some questions, so you can ask Rian to.
Hello, ma'am. I have a question.
Yeah, please.
I don't have a question directly, but I want you to tell us what conventions do you think that we have to study to have a good hold on this environmental law?
Yeah, I actually made a list of it. I'm gonna give you the detail. Just keep writing everything I didn't discuss. The three conventions which I mentioned is the 1992 Triplet Conventions. It's UNFCCC, CBD,
Okay.
UNCD. I'm actually mentioning in a short form. Okay,
Yes, yes.
and then there is the African Charter of Human and People's Right, which I personally love the most. I mean, it's one of the best ever conventions that has. I mean, this is basically, this charter is not just talking about, the environment, but it's talking about the human and people rights of Africa, because Africa is one of the biggest regions of the world. So if I'm not wrong, Principle 25, I think you have to read in this charter. I don't know about that, but I think it's going to be Principle 25 that actually discusses about the environmental protection. You have to read about it. Then there is the Montreal Convention, 1987. Then there is Kigali Amendment. Okay, for Kigali Amendment, time is very short. Kigali Amendment is very important amendment. It's Kigali, Kigali Movement, or you can say amendment. They're talking about the HFC gases, which are basically put in refrigerators and in air conditioners. They are also causing a lot of problems in our environment. So you have to read about it. Then there is a Rio Declaration, RIO, Rio Declaration. Then there is Aarhus Convention. It's AARHUS, Aarhus Convention. Read of it. Then there is Paris Convention. There is Sustainable Development Goals as well. So I think these are the
Ma'am,
important.
uh, which one you like the most? Like, which one you think that this one is the one?
All are important. That's why I have, I have underscores from so many. These are not the one. I mean, I've just discussed about one person. These are very important. World Heritage Organization, you have to read about it. You have to read about Brussels Convention, BRUSCWLS Convention
Yes,
as well.
yes, I heard that.
You have to read about Stockholm Convention, Paris Convention. These are all important conventions. I mean, all important.
Ma'am, I have written. Thank you so much.
No worries.
So, sure. Ma'am, should we move towards concluding the session?
Yeah, please, please.
Sure. So first of all, I will thank you for all of your engagements, your previous engagements with Wakalat Online, and very few people we can see connected to this profession. Actually they are actually contributing back to the field. So Miss Binish Shabazz is one of them. Shazad is one of them. So I will thank you, ma'am. I hope we will continue this wave and we'll connect in the future for the same cause. And hopefully, wish you best of luck in your career ahead. And that's all. We may continue our next sessions, inshallah. The continuous session upcoming. So meet in the next
Oh,
sessions.
yeah, let me just, I can say one more thing. First of all, thank you so much for such a delectable, the conclusion and the introduction as well. But, there are some points which I didn't discuss in this lecture because I already knew like it's a spring school session and there are so many other speakers as well. So I didn't actually hit on those topics as well as migration is concerned, as well as the judicial stuff is there. So we just stick to the point, whatever we had to discuss. So I hope the next speakers, whoever would be discussing about all that, will have like more fruitful discussion with all of you, and you will have an ample discussion and ideas of everything. Yeah.
Yeah, sure,
And
man. Actually, you explained plenty of things. I think it seems impossible to conclude all this convention in a single session, and you have done a plenty of contribution to this spring school we have initiated. So we will have other insights as well, but it's enough from your side. We appreciate that.
thank you so much. No problem.
Thank you.
Anytime for you guys. Thank
Jazakallah. Jazakallah for joining us, and goodbye, everyone. Good evening. Jazakallah. Meet in
thank
the
you.
next session, inshallah. Allah
Thank you.
Hafiz.